everybody ready? Ready? We negate today's resolution. Resolved, in the United States, plea bargaining undermines the criminal justice system. The Department of Justice explains that the two primary goals of the criminal justice system are to function effectively and to best meet the needs of the people of the United States to the maximum extent possible. Therefore, in today's debate, we should be able to look not only to impacts on the courtroom, but also to broader societal impacts with the utilitarian approach. Contention 1, efficiency. Because of a high number of cases in today's criminal justice system, plea bargaining is critical in providing efficiency. The Oklahoma Law Journal explains that plea bargaining maintains the fairness of a trial while improving the speed significantly, therefore still upholding the tenets of the criminal justice system and maximizing punishments. The average jury trial requires substantially more than 6 times the length of the average guilty plea hearing. Plea bargains produce twice as much total punishment as any possible punishment that would be produced by the trial by punishing more criminals in the same amount of time. Though plea bargaining results in less severe punishment, it is able to punish so many more criminals that ultimately more aggregate punishment is given out and society is benefited more on net due to less criminals on the streets. For this reason, Eli Noem of Columbia University found in an empirical study that $1 spent on plea bargaining is far more efficient in reducing crime than $1 spent on trials. Bruce Zucker of California State University further underscores the importance of plea bargaining's efficiency, noting that without it, the federal, state, and local governments would be depleted of resources to properly handle the administration of their justice system. 2 examples illustrate this point. First, Fordham Law Review cites the example of the Bronx, where plea bargaining was banned and massive backlog occurred. Since the imposition of the ban, the backlog of pending cases in the Bronx has increased by 24%, costing taxpayers $3 to $4 million annually. Finally, the ban on plea bargaining resulted in a 21% increase in dismissals because of a lack of resources to prosecute these criminals. Similarly, Professor Robert Wenninger explains that when a ban took place in El Paso, Texas, judges found that they could not move a much enlarged caseload. Because the system was so overburdened, judges couldn't handle the overload of cases and had to let some cases go unprocessed. Therefore, in a world without plea bargaining, thousands of criminals would go unpunished and the criminal justice system would be unable to function. Contention 2, recidivism. In a study of 100,000 released prisoners, Michael Gottfredson concluded that those with the longest sentence were most likely to commit crime again, and those with the shortest sentence were least likely to commit crime. In fact, Professor James Austin quantifies this impact, stating that those prisoners who received an early release from their sentence were 7% less likely to commit crime after just 1 year. Therefore, plea bargaining, by allowing for shorter sentences, significantly decreases recidivism rates. L.S. Branham of the American Bar Association explains that plea bargaining decreases recidivism rates for 2 main reasons. First, the certainty of punishment, which plea bargaining guarantees, is more important than duration of punishment in deterring offenders from reoffending. Second, prison is a school for criminals, and those who are incarcerated become more sophisticated criminals and more entrenched criminals. Therefore, shortening sentences serves to significantly decrease future crime rates by preventing criminals from becoming more dangerous. Contention 3, informant. Subpoint A, crime. The Brooklyn Law School explains that criminal defendants and their attorneys routinely offer information and assistance to help prosecute criminals in exchange for lesser sentences, allowing the government to prosecute and effectively deter crimes. St. John's University concluded that cooperator testimony from plea bargaining has helped to solve 250 gang-related murders and helped to convict 300 persons just in the Southern District of New York. In fact, Loyola Law School explains that without informants, law enforcement authorities would be unable to penetrate and destroy organized crime syndicates, drug trafficking cartels, and the likes, meaning that the criminal justice system's ability to deter crime would be devastated. Subpoint B, terrorism. Roger Smith explained that information can be extracted from terrorists during plea bargaining concerning terrorist groups, individuals, and activities that are as yet unknown to our counter-terrorist groups. This information can then be used to locate more terrorists. FBI Director Mueller cites the example of Mohammed Babar, a terrorist who, as part of his plea bargain, revealed key information regarding upcoming terrorist activity. This information led to the arrest of 7 men who were hoarding explosives and planning attacks around the country. Mueller later explained that if not for plea bargaining, that information could never have been acquired, and those attacks could not have been prevented. So for all of these reasons, we urge a strong negative ballot in today's debate.
We firm resolved in the United States, plea bargaining undermines the criminal justice system. Contention 1, plea bargaining distorts accuracy. The Cato Institute outlines evidence of sentencing disparity visited on those who exercise their Sixth Amendment right to trial by jury is today stark, brutal, and incontrovertible. The disparity is widened to an incredible 500%. John Langbeam of Yale University adequately sums up that it is, quote, therefore a deeply coercive system. that deters the utilization of one's right to trial and funnels individuals into a plea bargaining situation compounded by three factors that distort the outcome. First, Stephen J. Schlaffer of the University of Louisiana Law Review uncovered evidence suggesting 20% to 35% of all bargains were the product of circumvention, in violation of the sentencing rules. Opaqueness prevents regulation and codification fails. Second, Russell D. Covey of Washington Lee University argues that during plea bargaining, criminal discovery rules are not designed to inform a defendant fully of the case against him. For example, in the United States v. Ruiz, the Supreme Court created a precedent under which the state found prosecutors did not have to turn over exculpatory information during plea bargaining, as determined in the United States v. Kidding as well. Third, defendants, when they plead guilty, sign a provision that often waives one's right to access exculpatory DNA evidence. These three compounding variables result in wrongful outcomes and undermine evidentiary standards. Additionally, Stephen M. Garcia of the Journal of Empirical Legal Studies found 20% of innocent defendants plead guilty when faced with an average magnitude bargain, leading to a 13.33% increase in the amount of innocents found guilty than if all cases had gone to trial. Contention 2. Plea bargaining creates a prosecutorial conflict of interest. An article in Suffolk University Law Review outlines that plea bargaining institutionalized a perverse incentive for prosecutors to push for a plea bargain in weak cases to actually allow the prosecutor to maintain an impressive record of success in trial cases and convictions, subverting the traditional logic that weak cases should be tried in courts to determine true guilt. According to a Pennsylvania Law Review article, 85% of prosecutors cited the fact, quote, the government has a weak case as the most common factor in their pursuit of a plea bargain. Professor Wright of Wake Forest University also establishes scholars have shown that prosecutors often offer defendants plea bargains that seem to be extremely favorable when the defendant's culpability is highly questionable. Cardozo Law Review elaborates, knowing that gaining convictions in weak cases is not difficult, the prosecutor cares less about the strength of the case she brings. As a result, she is more likely to prosecute weak cases, reducing screening. Moreover, Michael O. Finkelstein of the Harvard Law Review found that more than 2/3 of marginal plea bargain defendants would be acquitted or dismissed were they to contest their case. In fact, without this negative incentive, the Alaska Judicial Council found, quote, the standard for screening of cases was tightened, with consequent improvements in case quality, a positive influence on the quality of cases, and a useful tool for prosecutors. Ronald Wright further found that plea bargaining, a trade-off with screening, simply reduced law enforcement accuracy by reducing evidentiary standards for these law enforcement officials. This trade-off works both ways. A simple dismissal rate of 13% following higher screening standards in New Orleans reduced plea bargaining by 90%, making bargaining virtually unnecessary. Plea bargaining simply reduced accuracy, legitimacy, and effectiveness. Contention 3. Plea bargaining eliminates countermeasures. Stephen M. Garcia of the Journal of Empirical Legal Studies finally argues that plea bargaining as a, quote, insurance mechanism disproportionately benefits guilty defendants, allowing for it effectively amounts to a subversion of adequate punishment. John Carnegie of Rutgers University empirically outlines, quote, habitual offenders appear to be using the plea bargaining system to their advantage, at the expense of society. For example, individuals regularly bargain down a point-carrying movement violation to a zero-point offense, bypassing negligent driver countermeasures. But the Century Council reports a meta-analysis of 52 studies on plea bargaining restrictions found an 11% reduction in crashes and injuries, demonstrating the systemically negative incentives within the institution. Therefore, plea bargaining alone is responsible for this increase in time because of the removal of rehabilitation measures, resulting in net losses for society. Thank you. For the aforementioned reasons, we strongly urge a pro ballot.
Is everyone ready? So you'd agree that the purpose of punishment is to benefit society on whole, right?
Well, see, the problem right here is that you're assuming the purpose of the criminal justice system is to simply punish people. It's not that at all. It's simply to ensure a fair trial. Now I have a question for you.
It's only to ensure a fair trial.
No, it's simply to ensure that everyone has a fair access to the same amount of legitimate information, essentially to uncover the truth.
So you're only
That
going to
is
be
the
looking to
ultimate
fairness?
purpose. No, it's to uncover the truth in the matter.
I mean, like at the point when the Department of Justice comes out and tells you that the ultimate goal of the criminal justice system is to benefit society to the maximum extent possible, how do you make this claim that fairness is all we should value?
First of all, essentially, what you're arguing is that actually one Department of Justice study, that one instance stated it was in the, quote, best interest of society. That's what plea bargaining is for. Sorry, that's what is the best interest
It said that
of
it said the primary goal of the criminal justice system is specifically to come out and benefit the people of the United States to the maximum extent possible.
Benefit the people of the United States by
Right?
providing
So,
a fair access to legitimate.
At that point, in order to uphold the criminal justice system, isn't it our burden to show that plea bargaining has an on-net benefit to the criminal justice system?
Well, let's quickly talk about this right now. So you agree that you say in your case, quote, plea bargaining creates twice as much total punishment, correct?
Sure.
Okay, then you say in your recidivism argument that exposing people to jail time increases recidivism.
I'm really glad you brought this up. So specifically what this recidivism argument is talking about is it's not about the total number of punishment years given in aggregate to all criminals. It's looking specifically to individual criminals.
You're right, let's look at individuals. Individuals that are now twice as likely to be put into the criminal justice system.
Sure.
These quote-unquote negative influences.
Exactly, but we tell you it's a good thing to convict them. Certainty of conviction.
It's a good thing
No,
too,
let me explain.
recidivism is wrong.
Let me explain. Certainty of conviction is a good thing, but the fact of the matter is that when you put individual criminals in for a long amount of time, that's a bad thing. But what we're showing you with plea bargaining is that we're putting individual criminals in for a less amount of time, but we're ensuring higher conviction because we're putting more criminals in.
Why is it bad to put them in for a long time?
Because specifically recidivism increases.
Because
certainty is a greater deterrent, and because when these
certainty is your only argument.
No, because when these people go into prison for long amounts of time, it makes it harder for them to reintegrate into society when they come back.
Okay, and when they go to prison at all because you double the increase in punishment, that same logic applies.
No,
really
it absolutely doesn't. It absolutely doesn't at the point when we show you specifically a comparative analysis that comes to the conclusion that certainty is a greater deterrent than severity in terms of.
Okay, then you're still contradicting yourself.
We're not contradicting ourselves because we're looking to individuals versus aggregate punishment.
You're not really explaining why it's not a contradiction. I have another question for you. Is the New Orleans criminal justice system collapsing around our ears as we speak?
Well, I'm again glad you brought this up because the New Orleans criminal justice system, like the Alaska criminal justice system that you brought up, is one in which plea bargaining is illicitly happening. So what that means specifically is that plea bargaining is happening under the table in ways such that plea bargaining is able to function, is able to uphold the system, but the system is effectively
So let me
dependent
give
on
you an
plea bargaining
analogy right
still.
now. Maybe in a police institution you have corruption. All right, basically there will always be a little bit of corruption. Doesn't mean you don't try to stop the corruption from happening. Because plea bargaining is negative, though maybe can overshoot some illicit avenues. In that regard, it's still negatively harmful, and we still can affirm.
I mean, again, you would have to prove that it has net benefits,
and then really
net negatives on society.
Would it be fair for me to talk for 6 minutes in my summary?
No, it would not. But see, plea
Okay,
bargaining
so
reduces punishment,
breaks the
so it would be
rules.
fair for you to talk for 1 minute if you
Okay,
wanted.
then we'll also be fair for you to lie about evidence.
I mean, it wouldn't be fair, but it would. Okay.
We'll take some prep time. All three digits? I mean, all digits. All right, let's begin. So let's start off with framework. Now remember, you're going to extend my partner's framework because my opponents didn't offer a competing one in their 4-minute case. And that's going to essentially be that we have to look to net benefits to society. My opponents essentially is saying crossfire that we always have to look to fairness and truth, and we agree, but we only have to look to fairness and truth as long as it's benefiting the people. If we get to a point where we're sacrificing benefits to people in pursuit of fairness and truth, then you're not going to vote off this impact. Now let's look specifically to my opponent's points. The first contention talks about how we're distorting accuracy, and they go on to talk about how we're circumventing the law. But I'd like to point out that the University of Affirmative actually says that judges are a check on the circumvention. Because before people take a plea bargain, what it says is that they have to present in front of the judge the evidence and make sure that they're obeying the rules. So a judge is going to make sure they're obeying the rules, and if they're circumventing them, then he's not going to accept the plea bargain. They then go on to talk about coercion and how defendants are getting coerced in taking plea bargaining because they don't have enough information. To this, we're going to have a few responses. First, Indiana State University actually tells us that the defendants' lawyers tell the defendants enough information to the point where they have enough information to make an informed decision. Information like this includes the likelihood of conviction, for example. So on that point, you can see that when the lawyers are actually helping this information deficit be lessened, it's not an impact for the negative affirmative. Furthermore, I'd actually like to point out that people aren't being coerced. Moisberger actually found out in his article that essentially when he banned plea bargaining, empirically, people were still taking guilty pleas. That means they were taking them voluntarily, and they aren't actually being coerced into them. So on that point, you can actually see that there isn't any coercion. Now, let's look to the next point, which is about innocence. And they talk about how innocents are getting wrongfully convicted. We have two responses. The first is that Samuel Gross of the University of Michigan did an empirical study of exonerations and found that innocents were only convicted because of plea bargaining 6% of the time, and the other 94% of the time were
due to trials. At the point where plea bargaining is used 90% of the time to convict people, it is clear that plea bargaining actually convicts far less innocents than trials, and the reason for this brings me to my second response. The fact that Stephen M. Garcia of the University of Michigan did a psychological study of innocence and found that they were psychologically less likely to take plea bargains because they knew they were innocent and did not want to get unnecessarily convicted. My opponents say that Michigan actually says that it's 20% of innocence, but that's not true. The study actually says 6%. Now let's move on to my opponent's second contention, where they talk about prosecutorial conflict of interest. And they first talk about how people are essentially using weak cases to get to avoid the trial system. And actually, William McDonald of Georgetown University found that prosecutors actually only file charges for which they have sufficient evidence for. And the reason for this is they value their reputation as being an ethical prosecutor over any other thing, even getting a false conviction. So on that point, prosecutors aren't actually being deceptive because they actually want to value their reputation. And the second point is that actually, again, as I told you in response to their first contention, the University of Hafia says that judges are actually a check on this. Because when the prosecutor has to present the evidence to the judge, and the judge is going to check if the severity of the sentence and the evidence of the sentence are correlated. The strength of the evidence are correlated. And if they're not correlated well enough, he's not going to accept a plea bargain. We then go on to talk about Finkelstein and screening, but I'd like to point out that Finkelstein actually agrees with us. Quote from his study: "One would have to assume that the plea bargaining process was far more accurate a method of determining guilt than the trial process." So he actually agrees that a plea bargaining is better at determining who's innocent and who's guilty. And my next response is going to be that according to the Journal of Criminal Law and Economics, plea bargaining is a screening process because defendants know whether they are actually guilty or not and can use this information to their advantage. Then they go on to talk about, in their next contention, then they go on to talk about Alaska and New Orleans and how this was successful examples of bans on plea bargaining. But I'd like to point out that Alaska and New Orleans, both according to Oklahoma Law Review, had illicit plea bargaining continued. They needed plea bargaining in order to have their criminal justice systems function. They then go on to talk about how plea bargaining is going to benefit the guilty, but I'd like to point out that leniency is actually a good thing because Florida State University did a meta-study of 111 different recidivism studies, and they found out that the increasing in sentence actually increases recidivism, and a decrease in sentence decreases recidivism. Because certainty of conviction is a greater deterrent of crime than severity of punishment, and actually when a person is in prison for a longer amount of time, he becomes more entrenched of a criminal, comes back to society, and commits more violent crimes. So for all these reasons, I urge you to negate.
Can I run some check? Can I keep running for a person? Thank you. All the judges ready? So let's start at the top of the con case. The first thing they tell you is that plea bargaining increases efficiency, and they talk about this increased speed you get if you go con in today's round. And I have a couple of responses to this point. The first is that speed and efficiency are simply impact multipliers in today's round. They're not sufficient for you to negate the resolution, meaning that if you do a lot of things badly, that's a reason for you to affirm the resolution, because the speed and efficiency point starts creating offense for our own side. So what we see is that whoever wins that justice argument is going to be winning this round. The efficiency point isn't a reason for you to negate the resolution. But the second response I have is going to deal with the crux of this argument. The reason our judicial system is backlogged and is overloaded by cases right now is because prosecutors push weak cases through. At the point where prosecutors have every interest to improve their win-loss record, improve their conviction rates, they're going to be pushing these weak cases through. This is how you get to the University of Pennsylvania Law Review study, which tells us that 85% of prosecutors are using plea bargaining because they say that, quote, the government has a weak case, end quote. I'll apply this with the Harvard-Finkelstein study, which tells us that 2/3 of these cases, if they went to a full jury trial, would be dropped or these people would be acquitted. At that point, we're telling you that in the United States, since you're innocent until proven guilty, and since full evidence is non-existent against you, these people should not be convicted of these crimes. Finally, my last response to this efficiency and speed argument in today's round is that we can prove to you that it's possible for our society to exist with a plea bargaining reduction. We're specifically going to give you Alaska and New Orleans. And now they're going to get up here and tell you that they weren't full plea bargaining bans because they were still implicit plea bargaining. But what these examples illustrate to us is that it is plausible to reduce plea bargaining to such an extent as to make it irrelevant and to get rid of these injustices in today's round. So specifically looking at Alaska, what we see is that according to the law library, the system adjusted after plea bargaining was taken away. According to the Washington Monthly, disposition time went from 192 days to 90 days, meaning that efficiency went up overall. We're seeing that the system simply adjusted. In New Orleans, we see the best example of case screening taking place as a mechanism we can use. They found that a 13% increase in case screening reduced plea bargaining by 90%. We're showing that significant plea bargaining reduction is possible in society. Also, they have to respond to all the mechanisms our judicial system has right now to deal with plea bargaining, to function without plea bargaining. Specifically, number 1, bench trials, number 2, case screening, and number 3, the more proper allocation of resources. So first, when we talk about bench trials, Tina Wan of the University of Southern California argues that they're just as efficient as plea bargaining, take away the coercion that we see, and allow people to use more constitutional liberties. With case screening, we see that we eliminate the problem of weak cases, cross-apply the New Orleans study, and lastly, if we more properly allocate resources, we can significantly reduce plea bargaining. Now, on to their second point about how, there were examples of Bronx and El Paso. Well, these places implemented badly. We need to give you one example of solvency to win this round. Now, to their point about recidivism that they talk about how certainty deterrence is the number 1 thing that's going to determine recidivism in today's round, but this point is entirely non-unique in this round. What we see is that certainty deterrence is also achieved by the pro in today's round, because the number 1 thing that determines certainty deterrence is the certainty that the law enforcement or the police will catch you committing a crime. At the point where we tell you the police and all this law enforcement exist in the pro world, you're not going to be voting off certainty deterrence. Furthermore, they tell you that these people are going to be more sophisticated, more entrenched in the system if they go to jail for too long. That's completely outweighed by their own point, which they tell you that there's more aggregate punishment overall. If there's more aggregate punishment overall, without the full information necessary, you're putting these people in the judicial system, in jails, when there's not full evidence against them. You're innocent until proven guilty. That's the standard we're going to hold them to throughout this round. Now let's go to their final point. They talk about how informants it's beneficial because of plea bargaining. There's point A and B, talk about crime and information and terrorism. Now I'm going to use the same responses. I'm going to group these together and respond to them. Number 1, according to the Golden Gate University Law Review, quote, 45.9% of documented wrongful capital convictions have been traced to false informant testimony, making snitches the leading cause of wrongful conviction in the United States. This sets our system up for perjury. That's a significant negative that undermines the justice system in today's round. The second response I have is, according to the McGraw-Hill Group, what we see is that this allows lower levels members of organized crime to escape scot-free. They're allowed to come back to the U.S. and commit more crimes, and that's a negative that hurts society. And lastly, the terrorism point, if we let terrorists escape with less punishments, that's hurting society overall, even if you evaluate with their framework. Thank you.
Are you ready for crossfire? All the judges?
All right, do you mind if that's the first question?
Yeah, you can. So you brought up bench trials in response to my first contention. Now, can you give me an example to when bench trials have actually been effectively implemented?
All right, so the point about bench trials was to illustrate that it is possible. And for example, they were implemented relatively effectively in Alaska.
In Alaska?
In Alaska and El Paso.
Bench trials in Alaska.
I mean, at the point where people have the option, wouldn't you be able?
But didn't we look specifically to what happened when we banned plea bargaining in El Paso, and we actually saw an increase in case backlog?
Right.
Didn't we also see that Alaska had to have plea bargaining in order for their system to continue to function?
First of all, you give me an example where plea bargaining reduction was implemented badly. Now, what I'm telling you.
No, wait. Why was it implemented badly? You're getting warned.
For example, all right. So this is the reason why I'm telling you that you should still affirm the resolution. What I'm telling you is that, for example, in New Orleans, when case screening standards were increased by 13%, that reduced plea bargaining by 90%.
But didn't the Oklahoma Law Review actually found out that in New Orleans there was still a high amount of plea bargaining occurring, even though it was supposedly banned?
Hold on, there was a 20% increase. Hold on, there was a 90% reduction in legal plea bargaining and a 20% increase in implicit plea bargaining.
So that's 20% is a big number.
What that illustrates to us in today's round is that it's possible to significantly reduce the plea bargaining in our society.
But you still need plea bargaining to preserve functionality.
Not really.
That's what New Orleans proves to you. They still needed 20% in order to have any type of functionality.
I mean, not really, because at the point where we're proving, I mean, the idea is
you still need some amount of plea bargaining to preserve functionality.
All we have to do to affirm the resolution is plea bargaining. The way it's being implemented right now is undermining us. Now, I have a question for you about your point about recidivism. Your basic argument to recidivism is that you're helping society overall. That's your framework, because you're basically, these people are coming out and recidivism rate are decreasing, right?
Yeah.
But according to your own case, if aggregate punishment is increasing and you're sending more and more people to jail, how does that help society overall?
No, so it's good that we're putting more people in prison, but with
Why is that good?
but with plea bargaining, No, because we're convicting them.
Wait,
But
why is
it's
it
good
good
that
that
we're
we-
convicting them
Right.
for a lesser amount
Right,
of
but
time.
we're
So we
convicting
need
them-
to
hold
put
on.
people in prison,
The
but we don't need to
problem
put them in
is-
prison
right.
for a long time.
Right, but the
we need to
problem
look
is-
at punishment on an individual
Right,
basis,
right. The
not on an
problem
aggregate
is
basis.
you're innocent until proven guilty in the United States. We're convicting them without having the full evidence to do so.
I mean, this goes back to your
Right.
innocence point, where I specifically showed you that your own Finkelstein evidence agrees that plea bargaining
Right.
is actually better at determining who's innocent and guilty
Well, I mean, that's,
than
I mean,
jury
that,
trials
that's
and
his,
other types
I mean,
of
that's his
processes.
ultimate opinion on the issue.
I mean,
you still have to respond to
that's his
hold
own
on.
conclusion of the study.
I mean, that's
their own study
hold on.
actually agrees
Hold
with
on,
it.
that's his opinion on the issue, but you
I
still
mean,
have
that's
to
his-
respond to the specific statistic that tells us that 2/3 of these cases would be acquitted if they went to a
That's
full trial.
Finkelstein, and actually Finkelstein
Right.
uses his own formula. He doesn't use
I mean,
empirics. We actually
I mean,
brought up the
what do you
empirical
mean?
analysis
I mean-
with Samuel Gross of the University
I mean,
of
unless there's
Michigan
a
when he found that it was
relatively-
6% in plea
Unless-
bargaining versus 94%
Right.
in other
See, you're still not responding to the issue. Unless there's a relatively major flaw in the study, it's really
I
not
told you,
responding to it.
the flaw in the study is that he agrees with us.
I mean, no, that's his final opinion. Is that, look,
That's,
I like
that's,
plea
his,
bargaining.
that's his conclusion. No, that's the conclusion that he derives from the
Or
results.
you're not debating the
You,
argument.
you can read the quote right
Right,
here.
now respond to the fact that 45% of these
Okay,
testimonies
45.
occur.
Yeah, but
because
actually, your
there's
same
testimony.
source says that the majority of these false testimonies doesn't come from plea bargaining, it comes from other types of testimony. We're going to run some prep time. You have 53.
Is everyone ready? There's three main reasons you should be voting for the con team in today's debate. First, the issue of efficiency. Remember, we tell you efficiency is necessary for the system to function, and this efficiency can only be created through plea bargaining. Now, my opponents come up here and they try to give you a couple alternatives. They talk about Alaska and New Orleans, but remember, we tell you that Alaska and New Orleans had illicit plea bargaining. These places, they needed plea bargaining to function, and without plea bargaining, they wouldn't have been able to function. So effectively, the only examples my opponents can actually give you of a real plea bargaining ban weren't even real plea bargaining bans at the point that they needed plea bargaining to function. Secondly, they talk about bench trials, but remember, the Oklahoma Law Review actually tells you that bench trials decrease the quality and they compromise quality to the point where bench trials are worse than plea bargaining. And finally, we give you the only real examples in today's round of plea bargaining and plea bargaining bans, and they failed miserably. We give you Bronx and El Paso, both of which plea bargaining was banned, and what we saw was a huge increase in case overload and a huge increase in dismissal rates. This is a huge negative impact because criminals were walking out on the streets free of punishment because their cases were getting dismissed specifically because of overload. Finally, my opponent tries to tell you that that prosecutors put weak cases through and that's what causes it. But remember how Rohan tells you that empirically prosecutors aren't doing this. They're not putting weak cases through because there's internal checks in the system such as judges. So for that reason, you're going to see that efficiency is going to be flowing to the con team, and for that reason alone, you should be voting for the negative team. So next, let's look to the argument of crime. Remember, under that we look specifically to recidivism. My opponents come up here and they try to point out this contradiction, but remember, we tell you we're giving out more aggregate crime, but we're giving out less individual punishment, and we're telling you that an increase in individual punishment is what ultimately increases recidivism, so that contradiction doesn't stand. But secondly, we tell you that certainty is a greater deterrent than severity. So what we're going to be seeing is in plea bargaining, the certainty of punishment is 100%, and at that point, plea bargaining is definitely going to be decreasing recidivism, as we show you empirically. We show you a meta-study of 111 studies, which essentially says that decreased severity leads to decreased recidivism. On the argument of informants, unlike other means of getting information, plea bargaining has internal checks to make sure false testimony doesn't happen. At that point, my opponent's response doesn't stand, but also my opponents don't even cite a study that's specific to plea bargaining. Remember, we tell you that the impact of this is that innocents are convicted less in plea bargaining. 94% of wrongfully convicted innocents are from trials, and only 6% of them are from plea bargaining. We're mitigating this problem, so for this reason, we urge a negative ballot. Could we use
Okay, so when it's ready. Oh, sorry. It's fine. Judges ready? Alright, so before I begin, two observations. Number one, don't let them extend their points without responding to our responses. And number two, you have to look at fairness in today's round. My opponents argue you should simply be prosecuting as many people as possible and preventing recidivism. If this was true, if we just killed every criminal, that would benefit society as a whole. You have to look at fairness. You can't operate under this totalitarian framework my opponents give you. With that in mind, there was one reason why you vote for us initially. And it's the idea that you distort accuracy. They basically argue checks of the system exist. If we were 20% to 35% of all the system, it exists in circumvention of the sentencing rules. The only thing the judge can actually see in a transparent system, at that point you can't actually prove that these checks are actually working or they're doing anything. Now they argue the judges must look to a correlation between the amount of evidence, but all you're doing there is undermining the evidentiary standard. All judges do is take a cursory glance at the evidence. It's not actually an effective check. It doesn't actually work. And then the second reason they argue is that you have no empirical evidence, which is directly responded to by our third observation in our first contention. We tell you when you sign a guilty plea, you waive your right to access DNA exculpatory information. That's why this 6% statistic is so flawed, because now everyone who pleaded guilty isn't able to access the information that would actually prove them innocent. With that in mind, we win this argument for a couple reasons. And number one is the evidentiary imbalance. Because you have this evidentiary imbalance they fundamentally don't respond to, you are allowed to withhold exculpatory information. Second, conflict of interest. They can give you as many studies as they want. When 85% of the prosecutors themselves, they purposely push through weak cases, they fundamentally don't respond to the simple fact. The point being, they're able to get them out of the system, benefit themselves, essentially allow for laziness, that's inherently negative. Is in fact simply increasing the amount of innocent people convicted guilty. Extend our Finkelstein evidence, regardless of the conclusion was 2/3 of marginal cases would have been found innocent if they went to trial. That I wanted to give you New Orleans as an alternative. One example had been correct, and the argument was still illicit. That illicit thing was still bad. Plea bargaining was still bad in that regard. Just because it illicitly happens doesn't mean you entirely negate today's resolution. Now, about efficiency, all it is an impact multiplier. Let's look at the second reason why you vote for us, and it's the idea of recidivism. But it's really this idea of countermeasures. Now, my opponents completely contradict themselves by saying you're just going to be increasing punishment for everyone, causing negative impacts to the whole, etc. But in that regard, you're actually going to decrease recidivism under their logic. But actually, you need to look at countermeasures. Now, countermeasures are what prevent people from coming back. For example, putting points on a person's driver license. Because you eliminate these countermeasures, which is the vast majority of crimes, cause an 11% increase in crime. For these reasons, I strongly urge you to affirm.
Are you guys ready for Great. Are all judges ready? So I believe you have the first question. Now you brought up the DNA exonerations, right? So when was that law implemented that people had to, when they would sign a plea bargain, they had to waive their right to DNA?
It was officially instituted during the Bush administration, but before that point, according to the New York Times, several states already had these waivers in place.
Sure, so okay, but when our innocence evidence is actually specific to the 20th century, do you agree that this ban doesn't apply?
Well, let's look at this logically, right? Let's say I pleaded guilty and I say, hey, could you look up some DNA exculpatory information for me? Do you really think they're going to essentially allow for me to get the information people went to trial?
And at the point where plea bargaining is being used more, yet less wrongful convictions are coming out of it, and the conclusion of your own evidence agrees with us, I believe we win the innocence one.
No, I think that's not our evidence. Well, you can't just simply conclude that at the point where innocents are being convicted under this system.
But they're being convicted less than trials. Plea bargaining is mitigating that harm because as
okay,
your
but
own evidence
it doesn't matter.
It's a better determinant of
this round doesn't ask us to compare the merits of plea bargaining to full jury trials.
I mean, that's not
just
true.
asking us. Once again, can I please fully just respond? It's just asking us: is plea bargaining undermining the values of our justice system?
Right, but to
at the point where innocents are being
able to look
convicted,
to
you're still going
a world with plea bargaining to kind of and compare to a world without plea bargaining to be able to understand how specifically we're going to be seeing the impacts of plea bargaining on the criminal
justice system. Here's the thing: for all you know, the 6% of cases wouldn't have happened if you didn't have plea bargaining. So that still supports our side. But then we tell you specifically
all you know means that
waivers,
clearly, I mean, like,
you can't actually
you're not actually responding to the evidence, which tells you that in a world without plea bargaining, there would be a lot more innocents being convicted for the reason that 94% of wrongfully convicted innocents come from the trial system.
Yeah, hold on, but we're not comparing plea bargaining as better than the trial system. We're comparing plea bargaining in and of itself.
We're not comparing it to trial system.
Yeah, you just did. That's what that statistic does. It just says that the trial.
It says that plea bargaining serves to mitigate the number of innocents that are convicted.
Please let me respond to that point. That point just says that the trial system is worse than plea bargaining for innocents. But the point is in today's round that we have to evaluate what plea bargaining does. And it undermines
mitigates the harm.
Right, but here's the thing, the trial system in and among itself may be imperfect, but all plea bargaining can do is replicate the rate at the trial at its absolute best, but all you're seeing is a diversion from the maximum standard, from the diversion of maximum accuracy.
We're telling you that not only replicates the rate of the trial, but it does it better.
Right,
like
so
we're telling you it makes the system better.
Who's going to best determine what influenced them? Prosecutors, right?
Sure.
Okay, so when 85% of prosecutors say they purposely push weak cases through the system that they weren't able to be convicted otherwise, how does it not support our side?
So your evidence is nice in that prosecutors are saying things, but when we actually compare your evidence up to the empirics, it doesn't stand. Because remember, we showed you that our empirical study from Georgetown.
What empirics have you ever brought up?
I told you, actually, you completely ignored the card I bring up in my 4 minutes.
It was a theoretical card. What prosecutors say no?
Wait, that card literally just said prosecutors do not push weak cases through. You gave no
Georgetown care about their reputation. They care
Erickson specifically concludes that what's happening is that these prosecutors aren't going to be doing coercive measures and
But
corrupt
why?
practices.
Right.
Because
Two
they say
responses
about
to
their
that.
reputation
Number
of
one,
being an ethical prosecutor.
two responses to that. Number one, they don't perceive it as unethical because it's part of the intrinsic system.
No,
But
that's
number
the
two, the
definition
best
of
part of their
ethical.
reputation is their conviction rate. People
Well,
can't actually see the
empirically they don't.
transparency
We can
harm my
debate the
opponents talk
definition
about.
of
It's not
ethical,
actually a
well,
legitimate impact.
empirically they don't do that.
And they break the rules 25% of the time.
We'll take the remainder. How much is that? Okay. One's ready? All the judges? I'll be starting with framework. So looking to framework, now remember, you're going to be evaluating today's debate on a net beneficial scale. So if plea bargaining is on net beneficial to society, then we win today's debate. Now let's look first to the main issues of today's debate. First, efficiency. Now remember, we specifically show you that efficiency is the prerequisite for functionality. Because without efficiency, without plea bargaining, we don't have a functional criminal justice system. There's no criminal justice system at all. The only examples they can bring up with a plea bargaining ban are Alaska and New Orleans and the bench trials. And I'd like to point out that in every single one of these cases, plea bargaining had to illicitly occur in order for the criminal justice system to be able to function. The only examples, they completely ignored the empirical examples we bring up with a real ban, El Paso and Bronx, when we saw a huge case overload and criminals had to be let go scot-free because we couldn't process all these cases. Remember, all my opponents can say to this is, well, prosecutors are putting through weak cases. But remember, empirically, that's not true, even if they say that. Because prosecutors care about their reputation as being ethical, and judges are also a check on this. Furthermore, my opponents also say that there's an information deficit. But remember, as we told you in my 4-minute speech, lawyers are the ones who compensate for the individual, compensate for the information deficit. Now let's look to my second point, crime. Now my opponents specifically say that we're contradicting ourselves, but we aren't. We're saying more aggregate punishment is good, but less individual punishment is also a good thing. Individual punishment with individual punishment actually causes recidivism. The more punishment you give to an individual, the more recidivism happens. And that's what Florida State University concludes in its meta-study of 11 recidivism studies. It says certainty is a greater deterrent than severity. Because plea bargaining has 100% certainty of conviction, it's going to be a greater deterrent. Second, severity of punishment is bad because prison is a school for criminals. It allows criminals to become more entrenched, come back into society, and commit more violent crime. Third, on the point of innocence. Now remember, their own evidence actually agrees with us that plea bargaining is better at determining who's innocent and who's guilty. We mitigate the innocence problem in plea bargaining because 6% of innocents are convicted through plea bargaining, 94% are convicted through other means in our criminal justice system. At the point where plea bargaining is used 90% of the time, it's actually going to be lesser innocence in today's world. So for all these reasons, I urge you to negate the resolution.
Please remain of our prep time.
Do you know how many seconds we have? 30?
That's time.
Are all the judges ready? So first let me address the framework. We evaluate today's run on what benefits society with fairness and equality. These are the basic tenets of the criminal justice system. Now look at the extensions they're trying to make. Don't extend the points that they don't respond are responsive to.
Now, for specifically, they extend the efficiency argument, extend our impact multiplier response as well. If we're going to start creating offense with the efficiency argument, if we tell you that justice is undermined, their only response to efficiency is that it's impossible to function. Where we gave you Alaska and New Orleans as specific examples where plea bargaining was reduced. The response is that illicit plea bargaining occurred, but that's bad too. Plea bargaining is explicit and illicit plea bargaining. At the point where they both occurred, and we're telling you that both kinds undermine the criminal justice system, we're thereby affirming the resolution. It doesn't matter what type occurred, we're saying that A, plea bargaining reductions are possible in society, but no matter what type they are, they both undermine the criminal justice system. Don't grant them that extension. Then don't grant them the extension of prosecutorial checks and this evidentiary thing, the guidelines they talk about, because you use the response we gave you. We tell you that 20 to 35% of the time, these sentencing guidelines are broken. You extend our response ruling on that point. Then lastly, their whole recidivism argument, the certainty deterrence argument they try to extend by completely ignoring our point. The primary source of certainty deterrence is where the police are going to get you, if the law enforcement are going to catch you. That's what's going to deter these people. Don't let them carry that through. So at the end of this round, you vote pro in today's round. Number one, because plea bargaining is distorting accuracy, directly relating back to the framework. And we see this because number one, the 20 to 35% of the time, it's violating these sentencing agreements. Next, you see that prosecutors are pushing weak cases through. Remember that I told you that this was the premise behind their entire case. Right now, our system is overlogged, our backlogged, because prosecutors are pushing weak cases through. It's one of the most important points in today's round. Extend the 85% source, extend the source where I said that 2/3 of these cases would be dropped in a full jury trial, according to the Harvard Law Review. You're innocent until proven guilty in the United States, and that's not being upheld by my opponents. So ultimately, this evidentiary imbalance, this violation of sentencing guidelines, and the fact that prosecutors have every incentive to maintain their win-loss record means that you should vote in affirmative today. For the affirmative.